So most people don't know this, but you don't actually need an attorney to help you sue in court. However, you do need to know the rules and you need to understand what courts are actually looking for when they review a case. So in this video, I'm going to attempt to give you a crash course on the basics of bringing claims to court and the things that you need to know so that your case doesn't get ignored or dismissed before it even starts. Now, who am I? My name is Ian. I'm the founder of Justice Quest. We are a legal operations and intelligence company, and we build legal tools and workflows to help deal with the burden of legal administration. Knowing the law and navigating the legal system are two different beasts. And so we use our technology, we use our knowledge of technology to help bridge those two gaps. All right, let's get into it. So first, you have the right to represent yourself, and this right is secured by the Constitution. The First Amendment of the U.S. Constitution says, and I'm paraphrasing, that Congress shall make no law abridging the right of the people to peaceably assemble and to petition the government for the redress of grievances. So in other words, bringing complaints before a court is your right. It is not a privilege. However, when a person proceeds without a lawyer, this is called proceeding pro se, and this is Latin for on one's own behalf. But in order to sue in court, there are three major things you need to possess. Number one is a valid claim, also known as a cause of action. Number two, a private right of action. And number three, the court's jurisdiction. If you are missing any one of these, your case can fail before it even begins. So let's break all three of these down. What is a claim or a cause of action? Glad you asked. A claim, also called a cause of action, is a formal accusation that a defendant violated a law, a statute, a code, or a legal duty directly resulting in harm or injury to you. It's basically the legal foundation of your entire case. And this is important because courts are not just looking for somebody who feels wronged on the inside, but courts are looking for legally recognizable claims. So this is why when people come to court with these emotional arguments and they say things like, this isn't fair, they lied to me, they ruined my life, I was treated wrong, that alone is not enough. Your facts or the facts of the case have to fit into an actually legal claim recognized by the law. So examples of causes of action might include something like negligence, breach of contract, fraud, defamation, and so on and so forth. Now, every claim or cause of action is built from something called elements. What are elements? Elements are specific facts that the law requires you to prove in order to establish your claim. So think of elements like ingredients in a recipe. For cake, you might need flour, water, sugar, eggs, butter, whatever. I'm not a cook, so don't kill me. But if you miss any one of those ingredients, then you don't have cake. So likewise, if a claim has elements and you miss any one of those elements, you don't have a claim. So let's talk about negligence. Negligence in general has about four elements. It has duty, which means that the defendant owed you a legal duty of care. It has breach, which means that the defendant breached that duty. 3, causation. The breach caused you some injury or harm. And damages. You suffered actual harm or loss. So if any one of these elements are missing, then you do not have a valid negligence claim. And this is why legal drafting is so important. When attorneys draft complaints, they are not simply telling stories. They are trying to plead to facts that satisfy legal elements. It is very logical and precise. All right, moving on. What is a private right of action? This is number 2. A private right of action is the legal authority that allows an individual to actually bring a lawsuit under a particular law or statute. And this is something that many people are not aware of because not every violated law gives a person the right to sue directly in court. Some statutes might actually require you to go through a government agency such as the SEC or the FTC or the EEOC, which that has to do with like employment law, or your state attorney general. And in some situations, only these agencies can enforce the law, not you. So even if a law was technically violated, that does not automatically mean you personally have the right to file a lawsuit over it. So when you're researching whatever claim you intend to bring to court, you need to confirm that the statute either explicitly or implicitly provides a private right of action before you start drafting anything. Otherwise, your case will likely be dismissed right away. Now, jurisdiction. Jurisdiction is the court's legal authority to hear your specific type of case, because not every court can hear every dispute. Even if you have a valid claim and you have a valid right of action, filing in the wrong court can still get your case dismissed before it even starts. So there are generally 3 things the courts look at when determining jurisdiction. The first is subject matter jurisdiction. And this asks the question, does this court handle this type of case? So for example, Small claims court handles certain limited disputes, meaning they may only handle cases that are under a certain amount of money. State courts handle many state law matters, and federal courts usually handle cases that bring a federal question, meaning there's a question of federal law. And so if you're bringing claims governed by primarily federal law, there are situations where you may need to file in federal court instead of state court or small claims. Now, personal jurisdiction. This asks the question, does the court have authority over the defendant? So for example, even if somebody violated a law or breached a contract, you still may need to sue them in the county or state where they reside or conduct business. And lastly, we have venue, which asks the question, is this the proper geographic location under the procedural rules? Some statutes specifically state where lawsuits may be brought or must be brought, so the venue matters as well. Now, here are some gotchas. Like, this can really catch people off guard. You can spend, months, weeks, or weeks or months researching a claim, and you draft, and then you find out that there are things that you were supposed to do before you even brought that claim to court. So, again, these are called conditions precedents. Common examples might include sending a formal pre-suit notice letter, waiting a required number of days before filing with a government agency first, or exhausting all administrative remedies. Employment law is a common example of this. So in some employment-related claims, you may first have to file with the EEOC before you are allowed to sue in court. Now, here's why technology matters. Once you've satisfied all of these steps, you have your valid claim, your right of action, your jurisdiction. The next step is to actually draft and file your complaint. But if you have ever drafted or even read a legal complaint before, then you understand how tedious and complex this process can become. Every element must be pleaded with supporting facts. Every deadline matters. Every procedural rule applies. Not only that, you have formatting requirements, research requirements, drafting requirements, evidence organization, motion practice, all kinds of procedural traps. A lot of people don't even lose in court because they don't have a case. They lose procedurally because they lose, due to logistics. So here's what's important to understand. Most entities that you are going up against, they do not just know the law. They spend thousands, sometimes millions of dollars every year on legal technology, legal research systems, automation tools, and litigation infrastructure. So if you are entering litigation without organization or technology on your side, in most cases, you're bringing a knife to a gunfight. And so this is why you should join our legal tactics community on Facebook. Search Legal Tactics Community by Justice Quest. And in this community, we work together as a community to help each other learn, the facts of law, procedure, give each other tips and resources. And most of all, in this community, you will have the privilege of gaining access to the tool that I've built called Command AI, where this is an all-in-one legal workflow environment. So it helps you summarize your case and organize your documents, and it helps you with legal research and strategizing and drafting your documents so that you don't have to worry about formatting. Now, it's important to know that this is not just something that you're dumping into AI and AI is giving you a magic right answer. I would never recommend anyone to use AI in that fashion. This system has been carefully put together, and it requires you to work with it. So it's doing all the heavy, tedious work, but you still have to think and strategize in order to get to your end result. However, it will dramatically reduce the energy that you have to put in to fighting a case in court, and it evens the playing field, so that you can spend most of your time thinking and strategizing rather than your energy just being drained by the burden of legal administration. So if you have any questions, you want to reach out to me, you can reach me at ian.b@justicequest.pro. That's ian.b@justicequest.pro. You can also add me on Instagram, justicequest.pro, or add my personal Instagram, dadgod. Do I have my channel? Yeah. dadgod_LB. And I'd be happy to answer any questions that you have. If you are a law firm, especially one centered on justice, civil rights, wrongful conviction, PI, please hit me up. I have a bunch of solutions that I've been waiting to deploy, and I would love to be of service to you. Thank you for your time.